exclusive episode of Surviving the Survivor. We bring you the best guests in all of true crime. Don't forget to subscribe and smash that like button. Here's your host, Emmy Award-winning broadcaster, Joel Waldman.
What's up, STS Nation? Deja vu all over again. Just finished a show about 24 minutes ago, and we are back doing two shows today. So excited to have you all joining us back. We are going to dig and dive deeper into a couple of aspects of the Donna Adelson trial. As you all know, by the way, I didn't say welcome to another episode of Surviving the Survivor, the podcast that brings you the very best guests in true crime. Can't believe I forgot that part, but I have that out of the way. But Donna Adelson, she, as you know, is charged with first-degree murder and the conspiracy to kill her ex-son-in-law, FSU law professor Dan Markel. He's really the central victim in this decade-long case. We're going to talk a little bit about jury selection tonight, and we're also going to focus on this trial through the lens of a judge. We always talk about it in the eyes of the government and defense attorneys, but tonight we're going to talk about it with Judge Jay Blitzman. He's not here yet. He is running about 20-something minutes late. He actually told us he'd be late. He is the first justice of the Massachusetts Middlesex County Juvenile Court Division. He's retired now. Prior to his 24-year judicial career, he was a public defender and was the first director of the Roxbury Youth Advocacy Project. Very knowledgeable. He teaches at a little school called Harvard, where Dan Markel studied the law and went undergraduate there as well. Louis Baptiste, you know the face if you watch the show. He's a regular guest. He is one half of Webster and Baptiste, a formidable law firm in Tallahassee. Louis was Dan's law student. His partner, Stephen Webster, who's on here often, he was Dan Markel's post-divorce attorney. So that firm in Tallahassee has direct connections to Dan Markel. Last, but certainly not least, Martin E. Radner. He's an attorney licensed in Michigan and New Jersey. His practice is focused on personal injury, civil rights, criminal defense. He's handled and tried cases in both the state and federal court systems. Mr. Radner is well known and respected by the legal community as a fierce advocate and skilled trial attorney. His YouTube channel, most importantly, is called Brother Counsel, where he breaks down and analyzes high-profile trials, which you can subscribe to if you go into the show summary and you click on the link that I always put in there, because we're trying to a rising tide, as Steve Cohen says, lifts all ships. So let's jump right into it. We're all Donna Adelson all the time. The trial is less than 3 weeks away. We just got news this morning that there's actually going to be a motions hearing this Friday at 9 a.m. And it's scheduled to be in 3B, which is a whole other story because there's dispute in this case about wanting to move it from 3G, the bigger courtroom, to 3B. But before we get there, Louis, you know Tallahassee as well as most. This pretrial hearing that's scheduled all of a sudden for Friday, there are some motions that have been filed by the defense and the state as well. But by the defense, the motion to dismiss the indictment, motions to suppress evidence, this motion to move courtrooms. What are we to expect Friday morning with Judge Stephen Everett presiding? It's scheduled to begin at 9 a.m. We're taking that live. Tim Jansen, I believe, is going to be doing the live color commentary with me. Louis, what should we expect?
It's going to be a busy hearing. If we look at it, we've seen that these are major motions, right? These aren't just these aren't superfluous issues that where sometimes in a defense lawyer, you have to file motions that you need to preserve legal issues for appellate reasons. And a lot of times you file motions that you don't believe in, but you just have to file them because it's a part of the course, right? It's part of the job. That's not what we're dealing with here, right? That's not going to be what we see on Friday. These are meaty motions that have been filed by the defense in terms of what they're seeking. For example, we'll get into it tonight, but just to throw one out, the defendant's motion to exclude evidence of trial as consciousness of guilt. That's a major issue. We talked about it before.
Lewis, can I interrupt for 1 second for a bad reason? COE, did you hear that? Meaty motions. We were just talking. It's a headline grabbing title. Let's make that the thumbnail as long as Lewis does not sue us. Go ahead, Lewis.
You can have it. You can have it.
Thank you. I love it.
And so if we look at, for example, the consciousness of guilt, I have no doubt, we talked about it before on this show, that they could have arrested Donna way before she got to that point on the plane, right? Right before she was boarding. They could have stopped her from boarding the plane, right? That moment, saving it for that moment right before she walks on the flight, that was done so that eventually a jury could see that video to create the narrative in the picture that she was literally steps away from fleeing. That's what narrative was created by the FBI in that very moment, right? It's not as if they run up and they don't know and they just find out she's there. That's not the case. And so when they're talking about excluding that, that's major, right? That one piece of evidence in Judge Everett's ruling on that has the ability to shape the entire case, right? The consciousness of guilt is some of the best evidence against Donna. And so if we were to see, which I doubt we'll see, but if we were to see Judge Everett grant the defense's motion on that, that would force the state to change their entire theory, their entire case. And so,
and there's not a lot of time. I mean, we're not talking about a lot of time now. We're talking 2 weeks from that point.
100%. And if you look at, and I'll defer in a second, or if you look at the motion to exclude the fact that when Donna Adelson initially left Tallahassee, she left without being interviewed, and they've sought to exclude that test. They've sought to exclude Investigator Isom from testifying to that by arguing that it violates her Fifth Amendment, right? That's a major legal issue. Obviously, we know the defendant's right to remain silent cannot be commented on, and to do so is per se reversible, right? That's what the case law says. It's an automatic reversal. But that's a little bit different of an issue. We're not dealing with a commenting on the right to remain silent. It's more a comment. It's a comment on the fact that an interview didn't happen, not that they refused to be interviewed, right? So it's a little bit different of the issue than saying a defendant declined to be interviewed by the police. It's different, right? And so this is going to be a major hearing. It's not going to be short. It's not going to be quick. Judge Everett is going to give Rushbaum the ability to develop the record because he understands that it's not so much. A lot of these motions are things that Judge Everett has already ruled on, right? Like Lacass's testimony. That's already been ruled on twice, right? We shouldn't expect Judge Everett to give a different ruling on that testimony than he's given in previous trials, right? That's already been litigated. But Donna Adelson has the right to her own record. She can't rely on Charlie's record. She can't rely on Sigfredo's record. And so Judge Everett is going to give Rushbaum a chance to build his record. But, to the best guest in the country, in the world, get ready. Friday is going to be a action-packed hearing. My favorite genre movie is action movies. Well, it's going to be the Navy SEAL of action movies on Friday because these are major motions.
Oh, there you go. Yeah. You heard it. Major motions. That is the title of our thumbnail now, or will be soon. By the way, this is the actual court document from today showing exactly what is going to take place. And you see room 3B there. And that's very well. At the very end, you see 3G, though. These court docs you need a PhD to understand them. But I think it's going to possibly take place in 3G. We're going to see, and that's going to be one of the things that Judge Everett will likely rule on. 3 hours, from what we understand, have been set aside. So as to Lewis's point, is not going to be a quick in and out 5-minute hearing. Donna will be on that Zoom for a prolonged period of time. By the way, very quickly, Lewis, I mean, the defendant will likely just be on a Zoom, right? We're not expected to see her in court.
I thought the same, but then I saw, I want to say there was an order a motion to transport, or I saw something when I was, looking at it the other day. So it kind of made me think on 812, we see an order to transport. And so I think she might be there in person. The case law is that the defendant has a right to be present at every critical stage. That's what the case law says. And so there's no doubt this is a critical stage. And so she could be present in person. I don't think there's a need. I think that for efficiency, Judge Everett might, ask the defense to have her there on Zoom. But if the defense wants her there in person, she has the right to be there in person because it's a critical stage. And I think Judge Everett would, if asked, lean towards allowing her to be there.
Yeah, and if
Brother,
I can,
please hop in, brother. No, well, brother, I was going to ask you, is this going to be sort of like a mini trial, pre-trial? I mean, is how significant or meaty, to use Lewis's word, are Dan Rashbaum's argument be here and or Alex Morris?
Okay, so it's not going to be like a mini trial like we just had in Shayna Gardner's case.
Yeah.
They're not going to be calling witnesses or anything like that. But to Lewis's point, yeah, this is going to be very interesting. And just to add on to one thing that Lewis was talking about, that specific motion to exclude the whole Vietnam, her attempt to leave and her one-way ticket and all that evidence that they want to exclude. There's a very interesting case that they mentioned in their motion. And in that case, there's one of the prongs, one of the elements to be able to argue, for the prosecution to be able to argue as flight, as consciousness of guilt, was there a significant delay in time between the flight and the commission of the crime? Now here, the commission of the crime was about 10 years ago, right? And her flight was like 9 years later. So that is one of the elements that the judge has to consider about whether this flight that Donna Adelson was taking. Now, of course, we all kind of know in the back of our minds what she was doing, but if you want to just look at it from the letter of the law, one of the elements that he has to consider, Judge Everett, is the time delay between the commission of the crime, not when you're charged, but the commission of the crime and the flight. Now, again, how much weight he's going to give to that to ultimately make his ruling, that's have yet to be seen, but probably not much. But shifting a little bit to the other motion, which I thought, like to Lewis's point, the other motion also is an extremely meaty motion. We have motions to dismiss all the time. All these cases, they always file some motion to dismiss, like Lewis was saying, a lot of times just to preserve the record, preserve all your arguments for appeal. But here, this motion to dismiss was very interesting because it was based on something called pre-indictment delay. So aside from what we all understand, and by the way, thanks for all the love in the comments. I see them. I appreciate them. And like Joel always says, better community here. So appreciate it all. But
brother, are you talking about the motion to dismiss the indictment? Because I was just going to say I'm no lawyer, but that's the one to me that sounds like there's no chance, no hope in hell for that to be granted.
Well, yeah, I don't think it's going to get granted, but I think it's a very novel argument, and I think I wouldn't call this motion frivolous because it's really based on some pretty solid law. And the question of whether it's actually applicable in this case, that's where the arguments are going to get into. But just to give your audience a little bit of a flavor about what's going on here, everybody understands that there's a Sixth Amendment right to a speedy trial. Everybody understands that. So if the government arrests you, they can't just say, you know what, we'll try you in a few years, have a nice time in jail while we get there. They can't do that. But here the question is, let's say you have all of your evidence that you have against an individual, a defendant. And then as the government, you say, if we just wait a few years, all of his exculpatory evidence and all of his witnesses that will come testify for him, they'll be gone or dead, or they'll be hard to track down. Let's just do that because we have all the evidence already. Let's just wait for all those witnesses and all his evidence that he can have to exculpate him. Let's just leave it for a few years and then charge him. Well, the case law is clear that you can't do that either. So if you can show by the defendant that the only reason that the prosecution and the government waited to charge Donna Adelson, why did they wait all these 9 years? If the reason that they waited was because to gain a tactical advantage, that would mean bad faith, and that would be reason enough for the judge to throw the case out. Now, the prosecution most likely is going to show that they didn't have all of the evidence 9 years ago. This was a process. They were accumulating more evidence every day, doing more investigations and doing more and more and more and more until eventually they decided to, arrest Donna Adelson. But in theory, under the black letter of the law, if they really had all of the evidence against Donna Adelson 9 years ago or 8 years ago or 7 years ago, and they just waited because of a tactical advantage, then the defense would have a very strong argument for dismissal for this reason, pre-indictment delay. So I thought it was very interesting reading that motion as an attorney, and I researched some of the law on that, and it's a very interesting area. You can't just wait for years and years and years to just charge someone. So yeah, like Lewis was saying, this is going to be a very interesting hearing, and I really wonder if the judge is going to actually make a ruling at the time of the hearing. I'm assuming he's going to write an opinion about it because these are such important issues. He's going to want to also develop his arguments in his opinion.
Well, he doesn't have a lot of time to write that. I mean, do you think that we would get the opinion the following week or how?
Yeah, I mean, probably I would assume next week or 2 weeks. Yeah, but I'm not sure if he's going to make a ruling. I mean, maybe on the other motion of consciousness of guilt, maybe he will. But this motion to dismiss, he may want to develop a whole opinion and cite a lot of case law and explain why it's not relevant in this case. I mean, I don't know. I mean, I'm just guessing, but I may be wrong.
And by the way, here the COE putting up another court document, just showing some of the exhibits and the state's answer to demand for discovery. So you're looking at a WhatsApp chat between Harvey, Scott Radius notes, Wendy Adelson, and Sarah Youssef emails dating back to 2017. You can read the rest for yourself, but the list goes on here. Just back to Brother Counsel's point, Lewis, can you pick up the baton on that one? I mean, for me, who's just the the non-attorney out of the three of us, kind of the layperson, it seems clear, obvious to me that there's no chance at all that Dan Rashbaum can win this motion for dismissal of the indictment because of the great period of time. What's your response to that? What's George's response to that going to be?
So I think that George is going to focus on. I think it's an interesting point. I think George is going to focus on if you were to look at the law, a lot of the cases that Rashbaum and Alex Moore cite to, a lot of those cases, and it's just a general area of law, it's based on prejudice, right? Which means that usually when we're looking at delay cases and motions to dismiss based on delay, it's usually the best arguments for delay are when a piece of evidence has gone missing. For example, some of the cases he cites to Rashbaum in his motion, a video, I think in one case, the appellate court said trial counsel was ineffective for not moving for dismissal based on delay because a video was no longer available, right? Another case, it was another piece of evidence that was no longer available. So usually, I think George's first response is going to be that that's not present, at least as I read it and as I see it, that's not a really big factor in this case. There's not a exculpatory giant piece of evidence, right, that's gone missing. Let's give a hypothetical. I think I'm a fan of hypotheticals. If because of time, let's say the Dolce Vita recording was now gone, missing. They lost it. It was corrupted. Something happened to it. And it was no longer available. That evidence no longer being available in the delay could now give grounds for you to file this kind of motion. I think because we don't see those issues, I do agree that when you look at the factors of delay, I agree with Brother Counsel. One of those factors I do think leans in favor of the defense. But I think looking at it overall in the fact that you don't have that ginormous missing piece of evidence. And when you're looking at delay cases, it's really the analysis is really a prejudice analysis, right? Which is the defendant prejudiced by this extended delay that was solely because of the state at the state's discretion? In this case, when I think about it in prejudice, the only prejudice would be the real prejudice would be that there was a big piece of evidence that was missing, not something that was routine or regular, but a major piece of evidence. And I don't think that's present in this case. So I don't think that Judge Everett's going to deny the motion. I think that brother's counsel's right. He's going to rule on Judge Everett first is the type of judge that takes things under consideration, right? I've seen Judge Everett in the middle of a sentencing walk off the bench and have us wait and come back to give a sentencing, right? And so he wants to consider it. He wants to believe in his answer. And so I think that on some of them, we're going to see quick rulings. For example, one of the motions was regarding, and the judge is here, so I'll make this my last sentence, but you got to give deference to judges always. I think one of the motions, no, not touche.
Even retired ones.
and one of
depends on the judge.
They know the active ones, and so in one of the motions, he almost admitted. He said, Rashbaum said, I imagine the court is going to deny this motion, and I'm filing it mostly for record purposes, right, regarding hearsay statements. And so that shows you that Judge Everett himself in Rashbaum recognized that this motion is going to be denied. He put it in the first paragraph. He just needs to file it to preserve the record.
Yeah, and we're going to get to the judge in just a moment. It is Judge Jay Blitzman, who I already introduced. Thank you, Judge. We're going to get to you in a second, but I wanted to let you follow up, Martin Radner, brother counsel. Yeah. And there's a question here for Lewis I'll ask of you. They tried the same motion for Charlie. It didn't work then. Why would it work now?
So I think that each case is different, right? I think that first, I don't think it's going to work. If I had to, place a bet, my bet is it's not going to work. But I think each case is different. I think one, in this case, you have more of a delay, right? It's every day counts, right? And there's more of a delay, I think, is the first argument. Two, I think that what brother counsel said is an important point, right? The analysis is, at what point did the state have the ability to fully prosecute Donna Adelson, right? That point can be different for Charlie than it is for Donna, right? So the analysis is not, was it 9 years for him and 8 years for her? And that's solely the issue. No. The issue is, at what point did the state have the ability, with all its evidence, to prosecute Donna? And at that point, what's the justification for the delay starting from that point, not before? And so I think that's a subjective analysis.
Yeah, and if I can just respond.
Hop in, brother.
Yeah. And first of all, I obviously also want to seek permission first from the judge. So in this motion, what they're arguing, the evidence, the exculpatory evidence, and Judge, we're talking about the motion to dismiss based on pre-indictment delay, that it took the government so long, 9 years of almost, basically, to charge Donna Adelson. So the defense moved to dismiss the case based on pre-indictment delay. So here, obviously, like Lewis was saying, the law provides that you have to show, number one, substantial prejudice, and number two, bad faith. So it used to be, actually, the law in Florida was that you just have to show actual prejudice, and then the burden shift to the government. Now the law in Florida is that you have to show, number one, substantial prejudice, and number two, bad faith. So the defendant has to show both. But in the substantial prejudice, what they argued in their motion was there's two pieces of evidence that would have been exculpatory to Donna Adelson. Number one, they say, is that, if some of you recall, that there was an expert who talked about the pattern of the phone calls from, I think it was May 2014 till July 2014, and showing the pattern between Donna, Charlie, then Charlie to Katie, and Katie to Sigfredo, and, showing this whole pattern, how it really looks like these people are doing something and they're up to no good. Now, one of the arguments that the defense argued is that because of the lapse of time, we're not able now to see the phone records prior to May 2014. And if we only would have been able to see all of those phone records going back years, you would have seen the same exact pattern, even though there was no conspiracy to commit any sort of murder. So one of their arguments is we can't get those records anymore because of this delay in charging Donna Adelson. And if we would have been able to get those records, we would have been able to show the jury that this pattern doesn't just exist in this 3-month period. This is always has been the case on the pattern of their phone calls. That was number one. And number two was, you all remember that Donna Adelson texted Charlie outside your house, right? That night when they were arguing that the reason why Donna did that is because she wanted to drop off money or whatever it is. And Donna's argument seems going to be that, no, we weren't outside Charlie's house when I sent that text. We were on our way to Tallahassee. We were driving from Miami to Tallahassee then. And what would show that Donna Adelson was traveling from Miami to Tallahassee? Well, the SunPass records. The SunPass records would show that clearly. But because of the delay in time, those SunPass records don't exist anymore. And because they don't exist anymore, we can't prove and show to the jury that she was actually in her car on the interstate or whatever highway she was on, driving, nowhere near Charlie's house. And again, because of the delay, we can't show that. So that's why they're arguing that there is prejudice. There is substantial prejudice here. And the only conceivable reason that they delayed is for a tactical advantage, which would equal bad faith. That's why they're moving to dismiss. Now, yes, there is a lot of speculation there about what the records would show. It's not like there was a video on that area, which if only would have gotten that video and now it's been written over, that would have showed clearly what happened here. It's a lot of speculation. That's probably what Georgia Kaufman is going to argue, but that is the prejudice that the defense is arguing for.
With all that said, Judge Jay Blitzman is here, and I'm ecstatic about it. He was going to come on last night. And I'm going to kind of shift the focus now a little bit to him, but I'm going to have obviously Lewis and Brother Counsel weigh in. But Judge, we always hear from defense counsel. We always hear from former prosecutors about preparation. Rarely do you hear from a judge. So Judge Stephen Everett is the judge who's going to be presiding over this case. He presided over the Charlie Adelson trial. They just announced, because I know you came in a little bit late, there's going to be this big motions hearing on Friday about these motions that they were just talking about. You as the judge, or Stephen Everett as the judge, what does he do in preparation for a big, high-profile trial?
Well, first of all, thank you very much for letting me join this conversation. Mea culpa, or as we would say in my old hood, my bad for being late.
No worries.
So what you do in preparation for a case like this is your homework. You read the motions, you read the case law, you educate yourself. Now, I read the motions that were filed on August 12th in anticipation of the conversation this evening. There are not unusual motions. Motions in limine are classically filed in advance of trials to inform which evidence is reliable and which evidence should reach the jury. The judge is the gatekeeper and makes that determination of reliability. So that's the first thing. And you do your homework, you prepare. And I'll say this, some of the issues that I've heard my distinguished colleagues discuss raise provocative issues. But, I was a trial attorney for 20 years. Before I became a judge, I tried 5 murder cases. I defended 5 individuals accused of homicide. I presided over many serious cases. The issues that are raised in the motions in limine are provocative. Most of them fall into the category of what judges always say to counsel, and I'm sure Lewis and brother counsel have heard this phrase, very provocative argument, counsel. These arguments go to the weight, not the admissibility. You'll have thorough opportunity to cross-examine and vet these issues on cross-examination. So, for example, just picking up on the last thread about the prejudice analysis, about pattern evidence that's no longer available because of the inability to have all of these records pre-2014, that's a provocative issue that can be explored in cross-examination. Now, the question becomes, when did Donna Adelson, when was she in the crosshairs of the prosecution? Now, obviously, it seems logical that she was on the list of possible suspects from day one. But I think, Lewis, you addressed this in part. At what point did the prosecution actually have probable cause to get an indictment against her? They may have had a strong supposition. Evidence may have been there. When did they actually have the legal ability to get a warrant for probable cause purposes to obtain these records? So that's part of the analysis. It may have been the tipping point as regards Donna comes as the evidence mounts, and then you have all these jailhouse phone calls. I love, by the way, I got a big kick out of the motion in limine, which includes the effort to try to keep out the jailhouse calls between Charlie and his mom. As the French would say to that, bonne chance. That's a trove of consciousness of guilt information. The conversations, of course, about going to Vietnam, whether or not that was a one-way ticket, consciousness of guilt, et cetera, et cetera, et cetera. And in terms of, the prejudice analysis, and delaying seeking an indictment against Donna, remember, for murder, of course, there's no statute of limitations. That's not to say that prejudice cannot accrue or exist through through issues that are stale and can no longer be explored. So, for example, the inability to show this pattern of conduct. But on the flip side is it really creates the opportunity for very, very robust cross-examination concerning how effective and how thorough the investigation was, because the defense is almost certainly going to argue whether or not Donna's being charged 10 years after the fact, that this is still a Russian judgment, that they were just waiting to charge her. And essentially, this is the defense argument, that they were just trying to bring in all of the people who were involved in this murder for hire, this conspiracy, when they had the appropriate evidence. But, in sum and substance, what my gut is, and it's heartening to hear that, there's a trial judge who was thoughtful, will be reflective. What I wanted to do when I was a judge is to make sure, and due process is the bottom line, is that both sides are fully heard, really get an opportunity to argue their case. And I always love when I had great trial attorneys in the room, because it made my job a lot easier. My sense as regards these motions, the bulk of these issues will be resolved with that old phrase that I just shared with you at the top of my remarks, which was, goes to the admissibility, it goes to the weight, not the admissibility. Meaning, we'll leave it to the fact finder to give whatever credence they have to whatever evidence, and to allow perhaps more expansive cross-examination in some areas. That's another way that sometimes judges do that, to explore bias, motive, and questionable police investigation when there's this rush to judgment kind of argument being advanced by the defendant.
I am getting a law school education here, and I love it. So, bottom line, Judge, and then we're going to move back to.
Let me just complete this thought, because this is sort of I was late because I was having dinner with a colleague of mine, and the dinner ran late, and it's a colleague that I tried murder cases with, and we used to joke, because we were public defenders together back in the day, and we used to joke about motions in limine that we used to file. So the classic defendant motion in limine. Now comes the defendant in the above entitled matter and moves to exclude all the evidence in the case against my client on the grounds that it's very prejudicial. And of course, evidence is offered, right, in a criminal case. It's intended to be prejudicial. The 403 analysis is whether or not it's unduly prejudicial, whether the prejudice is so inflammatory that it outweighs any probative value. But that's a classic defendant story that you will hear shared if you have in this context. So looking at the motion, I'm not saying that these motions in limine are that expansive. I think there's some legitimate arguments that are being raised, but I think they'll be resolved with this goes to the weight, not the admissibility ruling by the judge ultimately.
Two things, Judge. Am I supposed to say, may I approach, every time I ask you a question? That's number one. And question number two is, so what's your bottom line? I mean, are you willing to take a shot at a prediction here when it comes to this motion to dismiss the indictment because of this long indictment delay?
I'll take a shot. Judges are very, very worried, justifiably so, about a dispositive motion, a motion to dismiss. That's the death penalty, because it kills the right of the people to be heard. I don't think the motion to dismiss will be allowed. I think the judge will address it, thoughtfully, and I think he'll allow for ample opportunity to cross-examine on the issues that are raised as regards prejudice, and probably will we'll factor that into the way it's conducted during the trial. And remember, issues can always be revisited during trial. So sometimes judges take a motion at a revisement, some portion of a motion in limine, and will say, well, I'll reconsider that. I'll see how the evidence comes in. They ask for an offer of proof on an issue from the prosecutor. If the offer of proof isn't met regarding the admissibility of a piece of evidence, then defense counsel raises the issue, and then a ruling can be made. But as regards the allowing a motion to dismiss, given the history of this case, given the evidence, given the allegations, I don't think I'm going out on a limb and to say that the motion will be denied.
There you go. You heard it right here. After all that, just like a judge, talk for a long time, and then they say motion denied. So there you go. Abby Crossing.
Or as a judge always used to say to me, when I would make a motion, he would always say, denied.
Denied.
Now,
like
hopefully this judge will be a little bit more courteous, a little bit more respectful.
I like that. Abby Crossing, who's helps out the show, not just a friend of the show. We're going to get to this in a moment, but I want to get Lewis and Brother back in. How would Judge Jay analyze and subsequently rule on the motion to move courtroom? So this is the other big, one of the other big motions. And Lewis, to you, we did some homework. This is where Charlie's trial was. I love the body language here between Charlie and his attorney, Dan Rashbaum, and then Georgia on the other side. This courtroom holds, I want to say, 105 people in the gallery. Courtroom 3B, Lewis, is 21 people. So just with, if Harvey shows up, the Markels, that's already 4 people, leaving 17 seats. This is the juxtaposition of both. You see gallery capacity in 3B is 21, gallery capacity in 3G, 105. Dan Rashbaum made the case that we've got to switch to this smaller courtroom. How much heat is he going to have to bring to the table, so to speak, on Friday to have the judge grant this? And since there are a bunch of motions, in your opinion, Lewis, does the judge sort of have to throw Dan at least one bone, and could this be the bone that he throws him?
Absolutely not. I said it. I like to take firm positions. I don't like to ride the fence, because then you can say, "Oh, I said it." No, I take firm positions. It's what I'm known for on the show. There is no way, and I said it here, and if I'm wrong, I'll come back. But there is no way that Judge Everett is going to grant the motion to move this trial to 3B. 3B is a small courtroom, and it's only, and if you've been in it, you know how small it really is. Like at a busy case management, right? So Judge Everett has case management at 2:30 and 3:30, 3:30 for police, 2:30 for case management. On his private lawyer days, like tomorrow, Wednesday is going to be a Judge Everett private lawyer day. It's packed. We're standing, like the lawyers are standing, shoulder to shoulder, shoulders touching, because the room is so packed, because they have the in custody inmates in the jury box. And once you take the jury box out to play, the rows are, they're tiny. There's a little bit of seating to the left that, of course, only court staff can sit there because it's beyond the well. And so you're talking about that 21 is not even a real 21, right? That 21 is not, that's a fake number itself, right? I'm sure it's what they say, but that's a tiny courtroom. I had zero chance. One, the case law is clear. The public has a right to be present. I think the case law, that's abundantly clear. Two, every big case in this circuit is tried in 3G. It's not the Markels that are being tried in 3G. Every big case, every big murder case, every major hearing is tried in 3G. It's the best courtroom. It's the most updated courtroom. And honestly, it's the best looking courtroom, right? The judges know this trial is going to be nationally syndicated, internationally syndicated. You don't want to bring somebody to the worst decorated room in your house. You want to bring them to where the decorations look good. And so I could literally talk for 2 more minutes giving reasons why 3B is a no chance. And so to answer your question directly, I don't see a world in which this bone is granted. You just have to understand, if the judge were to grant this motion, the best guest in the country would not get to see the trial. There would be no space to set up cameras and everything you're talking about. There's not space to do that in 3B, right? If you go across the hall to 3A, 3A is a bigger courtroom, but it's bigger than 3B, but a little bit smaller than 3G, right? 3A is a courtroom where they try big cases in, and I've been there before, but 3B that's Judge Everett's regular room. It's a small courtroom. There's no way.
Brother, to you first, this question from Roxanne to you: the small courtroom is going to make the jury really see the pain in the Markel's face. This will backfire on the defense. That's another interesting point that I hadn't considered, but your follow-up to Lewis on that.
Yeah, no, I mean, I've frankly, I've never seen a motion like this. Maybe the good judge has, but I've never seen a motion like this to move courtrooms. I mean, I've seen it to move venue, but I've never seen to move courtrooms. Maybe I just haven't been in a big enough, high-profile case yet. But I will say that trying a case in a small courtroom is really, really annoying. It's just, it messes with everything. You just need a little bit of space to breathe. I've tried cases where the space between the counsel table and the judge's bench is so small you can barely walk around. Every time you turn around, you're bumping into something. It just causes the trial to just run that much less smoothly. So I would agree with Lewis that there's no way that I see the judge granting this motion. I will say one thing, because I saw something in the comments which I thought was interesting. And Joel, you did mention, do you have to say, may I approach? First of all, you say, may I approach a witness usually. To the judge, you say, can we have a sidebar? But I did have one time, I had a judge, we started a trial, and the judge said to me, he said to everybody, he said, we are not going to be asking if you can approach the witness. Okay, you can approach the witness. Just approach the witness without asking it. Because I don't want to hear this, same thing that's annoying everybody else. May I approach? May I approach? And I think that they said in the Karen Reed case, the judge said that you have to say, may I approach, every time you want to approach the witness. And yeah, it's just another annoying thing. Trials are annoying enough. It's long enough.
This was the judge telling you that you're not going to be able to say that?
The judge said, don't bother saying it. Don't waste your breath and time saying it. I'm going to say yes anyway. So just approach. So
I love this conversation, especially since starting next week, I'll be teaching trial advocacy at Harvard Law School. And we bring in all of these legal talent from around the country, and
I haven't been invited yet, Judge.
Well, I'll try to get you on the list. So, and everybody's got they come from different courts, state court, federal court, from the South, where there's more formalism. But this whole notion about may it please your honor, may I approach the court. Me personally, I hate that kind of formalism. My attitude, and this is what I try to teach as a judge, is if I respect you as counsel, and I know what you're doing, I know why you're approaching a witness. I know that you're refreshing recollection on direct. I know that you're impeaching on cross. I'm not going to insult you and slow down the trial. My job is to be an umpire and let the lawyers try their case and not be the case. So I personally second your motion. As, by the way, Reverend Lewis, I love the comment. Reverend Lewis, I was thinking of Smokey Robinson as you were going on about changing the room to a smaller courtroom. I second your emotion. Why are you going to move to a smaller courtroom, given the public's interest in knowing what's going on, the need for transparency, and the ability that you're talking about, brother, about letting people try the case? You need the space, and the public and interested parties have a right to see and know what's going on. The only reason, look, I was a juvenile court judge, and I rail against closed juvenile courtrooms because I think that I think the public has a right to know in serious cases. There's a public interest, there's accountability, and I think given the stakes in this case, and given fairness for both the state or the people and the rights of the defendant, a public trial means really meaningful access. It doesn't mean putting a trial of this magnitude in a cubbyhole where nobody can get into the room. It's shall we say, counterintuitive.
Lewis, to you, I mean, one of the issues that's going to come up here, this is obviously an enmeshed family. Expected to hear from Wendy Adelson, expected to hear from Charlie Adelson, expected to hear from Donna, and probably expected to see Harvey Adelson in the gallery. By the way, someone in the comments said maybe that's why Dan wants the smaller courtroom, so it makes it look like there's more supporters. Maybe there'll be another couple of family members. But in cases where a family member is involved in the conspiracy, Lewis, how does the law differentiate between direct and indirect participation? So what would Donna, I guess, in my terms, be on the hook for legally? They're gonna probably make an argument that, you know, she just believed whatever Charlie told her and was trying to keep her son safe, you know? So I guess the question I'm getting at is the foreknowledge that they have, and the actual participation or indirect participation. Is this a big factor in this trial?
So I think so, yes, right? So I think to answer your question, I have to like go back and like to educate the guests a little bit, like from a law school perspective. If we think about a conspiracy in general, once a conspiracy is started, the law doesn't care about direct or indirect, right? Because once you're a member of a conspiracy, you're responsible for everything that is born or brought forth from that conspiracy, unless you take specific steps to disavow yourself of that conspiracy, right? That's like criminal law 101, right? I had to go back there. But in this case, what it means is that at the point in which the state alleges that a conspiracy developed, right, to execute or carry out the murder of Professor Markel, at that point, the members of that conspiracy are responsible for all the actions of the conspiracy, right? Which means that as long as the state can show there was a conspiracy to do it, they don't have to show that Donna directed Charlie to staple the money together and hand it to Magbuana. That's not an essential element. They need not prove that that there was direct action, direct knowledge, a direct order, direct notice for that issue, right? Putting the cart after the horse is them showing that Donna was a member of this conspiracy. And once they show that, which I think there's more, you know, capital M, capital O, capital R, capital E, more than enough evidence to show that there was a conspiracy here and that Donna was a member of that conspiracy. And I think once you show that, all of the direct and indirect evidence is in play. Is my answer.
One of the things about conspiracy charges, which is so concerning if you're a defense counsel, is just how broad a net conspiracy casts. You know, in some jurisdictions require an overt act in furtherance of the conspiracy. Conspiracy also includes efforts to cover up the crime after it's occurred. It's so broad, you know, and it sort of runs afoul of this notion that you shouldn't have criminal culpability through guilt by association. So cases tend to be fact specific. Here, there's a lot of damning evidence that creates a lot of inferences that can be argued and will be argued by the prosecution. But I think the question that you pose, Steve, is a really, really, it's the Moneyball question. You know, the defense will vigorously say, you know, that or argue, you know, poor Donna gets sucked into this through her other family members and is just trying to protect the family. Now fears that she's going to be prosecuted. So you could always have the argument to refute it. But conspiracy is a really dangerous charge because it's so broad by its nature. You know, I always dreaded cases when I was a trial attorney where my client was charged with murder and conspiracy. I would always argue, let's dismiss the conspiracy, almost as although they're different elements. And then you have this whole issue of joint venture, co-conspirator liability. this case is incredibly nuanced and fascinating given the history. And what's really, I was thinking about this today. Charlie goes on trial, and you would think that at some point, if Charlie facing this jeopardy, or the other, his ex-girlfriend and the people who were involved in the shooting allegedly, if somebody had information to give directly against Donna or even Wendy, why would they not have by this point in time? So it's, usually, it's not uncommon for prosecutors to sort of work their way up the line, assuming that one defendant will crack and then give testimony against another. What's really unusual about this case is that has not occurred.
Yeah.
I mean, I find that really, really, and looking at this saga, which begins with the divorce in 2013, that this hasn't happened yet. And Wendy's going to be testifying on this trial, right? I assume under the same immunity agreement she had with Charlie.
Yeah. And by the way, we had a guest on, a lawyer last night, Jessica Mishali, Mishgali, I believe it is. And she said, to your point, Judge, in her opinion, she thought that the state should have tried Wendy first, even though the evidence is sort of the weakest, because she would have been most likely to crack if she was convicted. So I thought that was interesting.
Yeah. So they immunized her, which doesn't mean she can't be prosecuted. It means as long as she testifies truthfully, she can't be immunized. But that doesn't mean she can't be charged if they have evidence from a third source. So the investigation continues, or if some other person comes forward and rats her out, or if Charlie, whatever, says something at this late date, which seems incredibly unlikely. So yeah, but the progression about who got prosecuted first and the immunity deal with Wendy is really, really interesting. And now Wendy, when she testifies, she's locked in. Whatever she's, in terms of the scope of the immunity deal, she essentially has to, the contours of her testimony are informed and governed by what she testified in the preceding trial against her brother. She can't change, or else she'll be savagely impeached and cross-examined with inconsistent statements, and also she jeopardizes her immunity deal.
Yeah. Brother counsel, another point that's important, and obviously they're going to be hopefully picking an impartial jury. Donna does not have the best reputation in the court of public opinion. So how does the defense handle this? How does Dan Rashbaum handle this? I mean, does this have to be a concern of his, that there might be preconceived notions about her that he has to break down? Followed by this comment from Alice Feld, who's an attorney herself here in Miami. Wait till they show the Hitler Youth emails. That could be game over for her. Even though,
say what? Excuse me?
Yeah. So Judge is up in Boston. She sent she was exchanging emails with Wendy Adelson at one point to really try to peeve Dan Markel. She told Wendy that Wendy should dress the children in Nazi uniforms because he was becoming more Jewish from a Jewish grandmother. This is Jay Blitzman, the Jewish judge, cannot believe what he's saying. Oy vey. While he processes.
This is a shanda.
This is a shanda. Brother,
Yeah.
it's like a horror. Brother counsel. So what about breaking down the reputation here?
Yeah, I mean that's a good basis why they would argue that she can't get a fair trial in Tallahassee due to the ongoing nature of the past 9 years of this criminal trials and all that was going on. So that's exactly the point. Now they're going to try to ask every single juror there, have you ever heard of this lady called Donna Adelson? And and if all their hands shoot up, they can probably assume that they don't have the greatest opinion of her. So that is going to be an uphill battle for them unless they can get someone who's been living under a rock for the past 9 years and not hearing anything about it. It's a tough job. And I will tell you, Joel, that I've maintained from the beginning that I don't think it was a good move for Dan Rashbaum to be representing Donna Adelson. I think it was a better move for her to get this other attorney. Was it Alex Morris? involved. And quite frankly, when he went on your show, if you remember that, you gave him an interview on his show.
Yes.
And he was talking about what the defense is going to be in Donna Adelson's case. And he basically let the cat out of the bag. And he said that they're going to go with the same extortion theory. And as soon as I heard that, I was thinking to myself, first of all, I mean, I don't know why.
Unless he was bluffing. Unless he was bluffing. But I mean, I don't know. He was very adamant that that Charlie was extorted, and therefore she was trying to help Charlie get out of this extortion situation. I mean, I don't know if he was bluffing or not. Somebody actually has a bet with me that if he mentions that during opening statement, he's going to buy me lunch. So, but I've always maintained that I think that that's a terrible idea. I don't think that they should argue the extortion theory. I think that a much better chance would be that she didn't know anything about any extortion, about any conspiracy. All she knew was that Charlie was coming to her and asking her for cash because he's got a problem. And being a loving mother that she is, she just decided to give him money without delving into the dark details of what's going on. And she just was, a clueless mother. I thought it's not the greatest defense, but I think that as opposed to this whole extortion theory, which was a little ridiculous. And therefore, I actually put out a video explaining all this. And then I said that if it was me during jury selection, I would want to come away from this whole theory. And therefore, I would say to the jurors, the potential jurors, did anybody see my interview, if I'm Dan Rajbaum, did anybody see my interview with Joel on Surviving the Survivor? Because if they did and they saw what I was going to argue, then I can't make up a new argument. So I think it's a fair question to ask the jury, have you seen any of us give any sort of interviews on any news stations and hear anything about the case from that way, and make sure that the jury didn't, and then you can argue to them whatever you want. But
Yes, so
is it a little odd for a defense attorney to give an interview before a high profile case? Isn't it usually afterwards?
It depends. It depends. When I began, as a criminal defense attorney back in the day, a really long time ago, we were too passive. You've got to participate in forming the narrative, and storytelling begins outside the courtroom. That said, and this is where I'm going to sing again. I second your emotion, brother. You don't want to lock yourself into a theory, certainly pre-trial, which might compromise the burden of proof. The government's got to prove the case beyond a reasonable doubt. The second the defendant locks themselves into a theory, then you're running the danger of diluting the burden to preponderance. Whose story are you going to believe more? The greatest defense the defendant has is proof beyond a reasonable doubt. We don't have to answer the question definitively. We could raise, possibilities that create doubt. And here, how could you convict my client? My client's crime is that she's a loving mom. She loves her grandkids. She loves Wendy and her poor Charlie, and she's been the victim. She's been dragged into this. So I like that a lot better, and that doesn't require affirmatively coming up with a conspiracy theory, which gets really hard to prove. A defendant should never assume a burden of proof. We talk about third-party culprit and all that. Well, you could do that in a subtle way. You could suggest, you could raise possibilities, but don't lock yourself into a theory that A, you can't prove, and B, may be very, very attenuated. And as regards this issue of publicity, man, there should be extensive, there should be, the motions in limine are one thing. Jury voir dire in this case, the impanelment process should probably, if it's done well, take at least a week. I don't know what the practice of this judge is, but because you want
last
to go
time they sat the jury in 3 days last time. I was going to ask you that.
That sounds quick to me now, because again, with each successive trial, the publicity, the notoriety, it gets more and more extreme. And look, you're never going to find jurors who don't know anything. The stealth juror who says, "I've never heard about this case," they're lying. You want to be able to get a juror to say, "Of course I heard about the case. I don't live under a rock. I live in Tallahassee." The question is, can I be fair? The judge will say, "Can you be fair?" And so it's one thing. Sometimes judges short circuit that because they want to qualify jurors, and they'll say, "Look, I know you've read the neighborhood about the case, but you can be fair, can't you?" And the judge says, and the potential juror says, of course I could be fair, because they don't want, they want to please the judge. So you want to make sure that you really ask questions in a non-leading way during a voir dire. And I would welcome, of course, extensive attorney participation in the voir dire process, because this is a big issue. I remember when Dokar Tsarnaev was tried and convicted in the Boston Marathon bombing. In terms of change of venue motions, the judge said in that case, well, we could address that through individual voir dire, which, quite candidly, that's one of the cases where I thought a change of venue should have been allowed, because you can't, inconceivable that anybody in Boston is not affected directly, indirectly by, what happens in the Boston Marathon. So this case is maybe not to that degree, but it certainly has a degree of incredible publicity. And you really got to be thoughtful about the voir dire process. And you really want to make sure you do your best you can to get people who, if they have bias, they acknowledge it, and then you really believe will do the best to listen to the evidence as it comes in and to make a decision based on the evidence only and not on their bias and emotion.
Yeah. Real quick, Lewis and Martin, are you guys, I know sometimes you both have to hop at 8. I just want to be mindful of your time. Are you guys both good for a few more minutes? Lewis, I know you teach.
I am. I don't have a deadline. I have class tomorrow night, but not tonight.
All right. So we'll go.
I'm okay for a few more minutes also.
Okay. Probably go like 15, 20 more minutes. So it looks like Carm is back in the chat here. Everyone appears to be loving the show tonight. And how could you not with this trio on? If you are, including Carm, enjoying the show, please subscribe. It helps us. If you hate the show, that's even more reason to subscribe, because hate is a strong emotion, and you can hate us and you'll enjoy that. And I'll be bringing you joy to your life. You can also look us up on Patreon. That's a good way to support the show. So appreciate that. And tomorrow night, by the way, we are on to Corey Richins, the Utah mother and wife, the one who wrote the book about grief, who is now standing accused, and she's going to go to trial. It has been ruled. Stands accused of murdering her husband with 5 times the lethal dose of fentanyl. So we are doing that tomorrow night. We got Greg Skordas, the family spokesperson, and other amazing guests. Lewis, if you're Dan Rashbaum, what is your single biggest worry right now?
Georgia Kappelman. It's just it's easy for me. It's Georgia Kappelman. Being a trial lawyer.
And what can you do about it? And what can you do about the fact that Georgia is going to be on the opposing side?
Prepare. I think it's the only thing you can do is prepare, right? It's that when, I tell people being a trial lawyer is a contact sport, right? It's not it's not something you get into if you want to stay pretty, if you don't want to get into the mud. Trial work is sometimes ugly. Sometimes it's methodical. Sometimes, and when it goes right, it's the best recipe you've ever tasted. And when it goes wrong, you can't serve it. You got to throw it in the trash. I think that in this particular case for Rashbaum, look, the facts are what they are, right? But who you have on the other side, and in Georgia Kappelman and Sarah Dugan, you have methodical prosecutors, right? Georgia's not going to make many mistakes. And if she makes a mistake, she's going to clean it up so fast that if you're not on your P's and Q's, you're going to miss the fact that she even made it, right? And Alex Morris knows that. He's an extremely experienced lawyer. But I think that if I'm Rashbaum, you have to understand that defense lawyers, we thrive on the facts that, for example, me and my practice is that when I walk in the courtroom, I want to know my case better than anyone else in the room, right? Because a prosecutor has 200 cases, right? I don't have a 200 caseload. Never let it get nowhere near that. And so my success is that I know my case the best. I know the facts the best. I know the witnesses the best. I know the information the best. That's, God, all the other things that I hope line up in favor of me. I'm going to know the facts the best. Rashbaum can never know these facts better than Georgia. He can never know these facts better than Dugan, right? And so you have to walk in the courtroom knowing the other side knows it better. Georgia's tried this case, nuts and bolts. She's tried it, 4 times, right? That's a lot to try a single case, And so I think to me, the single biggest thing he has in Sarah Dugan, I don't say Georgia, Sarah Dugan is an amazing lawyer in her own right. But they're both good. On this case, they're great because they know it so well. They know everything about it. They know the rulings, they know the motions, they know the evidence, they know the periods and the commas. And when you have prosecutors who know a case that well, it's hard. It's hard to do anything. It's hard to do anything about it, or for Rashbaum to find. Last thing I'll say is trial work it's boxing. You're looking for that hole to land that punch. Good luck. You know, it's like trying to land a punch on Floyd Mayweather. That's what he has to go do. Rashbaum has to go in there and knock Floyd Mayweather out. It never happened.
Dude's undefeated in 50-something fights. Black Widow, Republic of Ireland, CARM not having a membership, that is my mother, of course, is affecting my sanity. COE, can we please get her a membership? Also, CARM has texted me 37 times today to get her the newsletter. We do, anyone who wants to subscribe to the newsletter, you can email us at survivingthesurvivor@gmail.com. But we have CARM-isms, things that only CARM says. And so CARM loves to read about herself. Therefore, please, COE, get her the newsletter so I do not have to be harangued about it. Also, CARM chimed in to say, I misspoke. I guess I said that the jurors were seated in 3 hours. If I said that, that's not correct. They were seated in 3 days, the jurors. But you heard the judge say it might be longer. There's not only one judge here. There's I'll Be the Judge, who says same thing. Thank you to Super Planner Girl for the newsletter. I'll Be the Judge says to get CARM a membership as well. So contrary to the question I just asked Lewis, to you, brother counsel, you heard no one knows this case better than Georgia Kappelman, but you can't go into a trial of this magnitude without some trepidation. What is her single biggest concern right now?
Oh, what would be her concern about this case? I mean, she's got I guess her biggest concern would be if by some miracle, the judge precludes this whole evidence of Vietnam, because that really is such a nail in the coffin. In case you didn't have it all wrapped up before, now that you have her one-way ticket and Googling non-extradition countries and all that stuff. I mean, the only thing that I can imagine that she's sweating about a little bit is if she's probably not, but in case in the back of her mind, the judge may just grant that motion and preclude the mentioning of her trip to Vietnam, because it just takes the nail out of the coffin. You still have a really solid case, but that's going to really, I think, like I said, put the nail in the coffin there. So I think that's the only thing. Probably tomorrow, by Friday, when the judge most likely denies that motion, she'll be just, swimming, no problem with with anything. So. I think really it's more about Dan, like Lewis was saying, Dan's got the issue here. And I think that something that I think is overlooked in a lot of trials, which I always talk about on my channel, is that jury selection. I know that this was supposed to be more about jury selection, but jury selection is really so important, like the judge was saying. And when judges kind of take control of it and they take it out of the hands of the attorneys, and it really upsets me because there's so much work that I need to really establish in jury selection, in my themes, in getting jurors to kind of understand, when I'm going to be making arguments. I want to see which jurors are going to be more receptible to some of the arguments that I'm going to be making. So and I put a lot of time, and I think that some of the attorneys that I watch, I'm surprised that some of the attorneys don't take jury selection as seriously as they should be, because they just get up there and maybe ask a few questions about seeing things on the news or anything like that. They don't start really laying the seeds for what their case is going to be like. And I think it's a big mistake. And especially in a case like this, where you're going to be if you're Dan Rashbaum and Vietnam's coming in, you're going to want to see, does anybody here ever book one-way tickets? That's obviously going to be a question asked. If you have somewhat of a, does anybody book one-way tickets? Right. Does anybody, feel that the government may be out to get you? Does anyone feel that, the police are unfair to you? Does anyone feel that they can't trust the system? And that's then, because that's setting them up for the argument that, hey, when I close and I argue and I say that Donna Adelson this is not consciousness of guilt. She was just scared because she's really innocent. She's going to get locked up by a system that's unfair. That's the argument that he's most likely going to make, or he should make, if the Vietnam sum cuffs in. So you want to start already preparing the jurors for that. So, it's a shame we can't really see jury selection, because it's really interesting. The good attorneys that I've seen really do a great job on jury selection in preparing the jury for what they're going to be arguing. And also, like when the judge mentioned that sometimes the judge will kind of steal your fire and say, well, can you be fair and impartial? Like, you've been working on this juror for like 10 minutes, when the juror's finally agreeing that maybe they're not going to be so fair and impartial, and you're kind of chipping away here and there. And then the judge will stop you and say, well, can you be fair and impartial? And then the juror will say, yeah, I guess I could. And then, that kind of steals your whole thunder. But yeah, I mean, it's such, especially in a trial like this, when you're Dan Rashbaum, you got to be thinking very carefully about jury selection, which I also was critical about them bringing in some sort of juror expert.
Well, they brought in, that's what I was going to say. They brought in a very high profile jury consultant, Josh Dubin, in the last trial.
They brought in Josh Dubin, and I was critical of that, because when I need the jury to really buy an argument, that's fantastic. I mean, like, especially in these type of cases. And if you're gonna be the one making that argument, then you've got to start building that relationship with the jury from day one. And if you just hand it off to Josh Dubin, who's spending 3 days talking to the jury, and you're not getting any sort of relationship with them, and then he flies back to New York, and now you're starting over. This is your first time talking to them.
Exactly. By the time you begin a trial, you shouldn't be doing, hello, my name is Jay Blitzman. I am privileged to. By then, you should be launching into your opening statement, because you already have a relationship. And so you start telling your story immediately, and the jury selection process is key. I'm smiling as you talk about your experiences in front of a judge. I call it the judicial head nod. Judges start doing this. I would always frustrate me. I've asked a great question. I got the juror on the ropes. I don't want to use a peremptory. This clearly should be a for cause, right? Those peremptories are like gold. I'm counting them, and I'm saying that this is clearly a biased juror who can't be salvaged. Then the judge says, "Well, I know you answered that question, that you tend to believe the police, more than other people, and I know that your father's a police officer, and I know that your father talks to you every day about his cases when he comes home, and I also know that he works in the county that's prosecuting this case. I understand all those things, but you're a citizen, right? And you understand the presumption of innocence that I explained, right? So I assume you'll follow my instructions and do the best you can to listen to the evidence." And I'm apoplectic. I'm going like, I'm objecting, and of course, you can only go so far. And then the judge, of course, does this juror. He finds the juror to be indifferent, which means, I got to use a peremptory on a person that a third grader would have disqualified, for bias. So that's always the danger. That's why a fair judge is worth his weight in gold, or her weight in gold.
Judge, Dan Markel went to Harvard Law. Harvard Law students, they're the best. They're the cream of the crop. You're the professor. You're the man that they look up to. Do you have to knock them down a couple notches in the first day or two of classes to let them know that you are the judge and they are the students?
No.
I
mean, I had a gavel, on my bench. I'm proud that in 24 years I never had to use it once, or if you got to bang on a bench or yell at people to get respect, then you don't deserve respect. You get respect by treating everybody with respect. And that includes how you engage with students. You want people to be excited. You want this to be a collaborative learning process. And I learn. One of the things I love about teaching is I learn from students. I learn from other attorneys. I learn from other judges. Once you stop learning, you're in trouble.
Yeah. By the way, my own mother, Carm, suggested the other day that I go back to law school. I'm wondering if Judge Jay could help me get into Harvard. I would do it for sure. Move the entire family into Judge Jay's living room. He can babysit, and I'll go to Harvard Law.
based on this personal basis of knowledge that we're forming, I could attest to your singular skill set and qualifications.
Perfect. I love it. Another question for the judge, because the judge is the judge, and then we'll get some final thoughts. I mean, in general, what are your thoughts on televised trials? Should trials be televised? Your home state, New York City, New York State, known to be very anti media.
This is a great question, because I just spent a weekend with one of my, I was away at a friend's house for the weekend, and one of the people there was one of my dear friends, who's Jane Rosenberg, whose book just came out regarding her experience as a courtroom artist. She's the sketch artist.
Oh yeah, from New York.
Drew the picture of Donald Trump that was on the New Yorker magazine. And so, in spite of my love for Jane, I think trials should be televised. I think this is all about accountability and the right of the public to know. I think federal trials should be open to the public. I think juvenile court proceedings should be open to the public. You could balance public and privacy interests, because the public has a right to be educated. The public has the right to know. They shouldn't get their news or their opinions distilled through third parties, through surrogates. And some of these issues are kind of consequential in terms of the quality of due process and the quality of fairness. And you could open up the courtrooms without making a circus. You could have one feed that other channels could share. That's what happens in Massachusetts, where we have open courtrooms. That's what happened that's what's been happening in the Karen Reed case. And I think, it really helps the public understand the dynamics of a trial. They don't rely on out of context reporting. So I think there's more to be gained by transparency, because I think transparency is part of public education and due process.
By the way, I hope this isn't true that only 89 people. You better hit that like button, people, please. You got the judge. Can't embarrass me in front of the judge. You got brother counsel. You've got Lewis all here. Judge, speaking, just the high profile nature of this case, what kind of added pressure is that on the judge himself, on Judge Stephen Everett? Does he, I'm sure he goes, through the same motions, so to speak. I'm sure he approaches it like any other trial, but you've got to think, the cameras are there, Nightline, ABC 2020, they're all watching. So is there something extra you do?
Yeah. So, I've tried high profile cases when I was an attorney, and I've presided over high profile cases. I like to think that, at least speaking both as a litigator and as a judge, that these kinds of cases should bring out your A game. You're being looked at, you're being scrutinized. It should make you better at your craft, better at what you do. The danger, of course, is to let it become a media circus. We all remember what happened with poor Judge Lance Ito in the O.J. Simpson trial. He was much too conscious of the media, and that got totally out of control. So you shouldn't pander, but there's a way to do it in a way which you have decorum, you maintain an orderly proceeding, and you proceed accordingly. But I like that kind of scrutiny. You don't have to explain what you're doing. It's visible. I like, in terms of high profile cases, I always prided myself on my ability to write careful findings of fact and conclusions of law. That way I didn't have to worry about speaking to the media, which is frowned upon anyhow. If you're a judge, I could say everything I have to say is in the public record.
Martin Radner, also known as Brother Counsel. He's an attorney licensed in Michigan and New Jersey. Most importantly, he's got a YouTube channel called Brother Counsel. You can go into the show summary, click on the link to become a member. There's a question here, and we'll get your final thoughts. I'll be the judge. Says, since a good deal of her testimony in the past has been used to show Donna Adelson in a bad light, how do you feel Wendy Adelson's ever-evolving testimony might be different this go around? Good question. Wendy is known for her K-turns. There you go.
Well, and I'd love to hear from my colleagues who maybe have followed the evolution of her testimony more than I. But I'll begin on this where or I'll end on this where I began, and that is commenting on her immunity agreement.
Yeah.
She is locked in to her testimony. If her testimony evolves or changes, she could jeopardize herself. So the immunity deal she has only lasts if she's testifying truthfully, whatever that means, truthfully. But we know that I think she's got to testify consistent with what she testified in her last trial.
By the way,
since she's had this immunity agreement.
This is breaking news. You mean I'm official now? Carm now has this wrench, so I guess she's either a mod or a subscriber. It's unclear which, but Carm can be modding the chats. Brother Counsel, just back to the Wendy Adelson testimony. Do you see it any different? And your final thoughts as we begin to say good night.
Yeah, so obviously I'm not going to disagree with the judge, but I think she's going to stay consistent that Donna was very close with her. They were extremely close, and that she was very, very involved, hands-on with everything that Wendy was doing, including obviously her extremely messy divorce. And that's prompted all of those extremely ugly emails. And it's just a very concerned mother. Of course, the jury's not going to unhear or unread, unsee all of those comments, and they're going to have their own opinion about Donna Adelson. So I don't see Wendy's testimony changing too much. I think that general theme that the prosecution is going to bring out, that this is an unhinged woman who will do anything and did do anything, they're going to continue with that theme, and they have a very, very strong case. So that's how I see this coming out. I also wanted to just remind everybody that Joel has a book also that you should all make sure.
You are a true friend now, brother. Yeah.
I would never bring that
out.
I didn't hear you mention that. So
I was just thinking I don't mention it anymore, and also
I'd like yell at me. And I also like to say that what the judge was saying about having these high-profile trials televised, I gotta say I appreciate it myself as a lawyer, because, like the judge says, the day that you stop learning is the day that you get weaker and as an attorney. And if most attorneys specialize in a specific area of law. You basically know your area of law pretty well, and there's not much learning going on there. So when I personally started my channel and I started watching all of these trials and learning some other jurisdictions and other laws and researching them, I love it. I love learning more stuff. I love doing the research myself, sharing that with my channel and sharing that all that I've learned with everybody else. And that's why I think it's so important to have the more information out there, the more that we can create curiosity from other people, that they can now do their own research and look into laws and find channels like yours and mine. And you hear from the judge and hear from Lewis, hear from, educated people who can talk about this thing and just learn more. We have the tools at our hands to learn so much more in today's day and age than they ever did. So let's take advantage of that. Let's open up everything. Let's try to have more transparency, which will encourage more curiosity, which will encourage more learning. So that's what I love about it. And I think that they should keep televising more trials and prompt everybody to learn more, because I love it. And being curious, it really gives you a lot more of a sense of living than just knowing your 5 case laws and statutes that you use every day in your own practice. So
the passion is palpable among these best guests. Since he opened the door, I don't know what that's called legally, but Martin just opened the door. The book is not about me, and it's really not about my mom, but it's life advice from my mom. And I guarantee you it will change your life if you read it. It's 10% Holocaust survival, and the rest just her take on different things in life. By the way, this has nothing to do with anything, but Carm and I are going to be guests on a show called Coast to Coast, which I've been listening to since 1996. It is the most listened to overnight radio show in the world. It's on 640 stations, and we'll put something out on YouTube, but we were asked to come on as guests, as true crime guests, and we're going to talk this case and the Honey and Barry Sherman case up in Toronto. They were the 10th or 11th richest couple in Canada that were murdered. That crime has never been solved. And of course, maybe I'll get in a book plug on those 640 stations. The man who needs no plug is Louis Baptiste, one half of Webster and Baptiste attorneys at law in Tallahassee. And Louis, of course, is Dan Markel's student. Louis, I'm going to leave it wide open for you to close this out any way you want.
A couple things I'll say is, one, I thought that obviously great points by brother counsel in that, look, I think it was a major mistake not to have trial counsel do jury selection. The entire relationship, the connection is established in jury selection. It's almost like getting married with no courting process, right? The courting process is jury selection, right? Before you actually propose in asking the jury for a verdict, right? And so I think it was a major mistake not to have that courting process. Two, I think the judge made a point earlier, which is that someone said maybe last night that Wendy should have been indicted first. And earlier I said that everything in this case Georgia has known about. The one thing that I believe, just total my speculation, that Georgia didn't see coming in this case, and people don't, and it's talked about, but not as much as it should be, is that Magbuana didn't take a deal. I think that when the state attorney workshopped this case in their office with their division chiefs, they thought that she would flip. I thought that she would flip. She's a single mother of children, right? The belief was that she would flip early on. And if we look at it from that belief, if she had flipped, like a reasonable mother probably would have, right? Like the state was offering her a sweetheart deal, right? No prison. You know, I mean, the deal they were offering is insane of what she was, what she could have got if she flipped. And so the idea that Magbuana would refuse to flip is something that I don't think the state attorney's office could have even calculated as reasonable. But what we saw is the derivative from that decision of her refusing to flip. Sigfredo goes to trial. She has a retrial. All that's not supposed to happen. Luis Rivera, he flips early on. If Catherine flips, then what do we see? Most likely Sigfredo takes a plea. There's no trial there, right? If Catherine, his baby mother, is going to testify against him, the mother of his children. And so I think her refusing to flip was the only thing that was unpredictable. And I think that single decision changed the entire trajectory of the prosecution of everything. The entire case was changed in that single decision that Magbuana made. I would also say that I agree with the judge, and final thoughts is that, look, I hope Rashbaum changes his theory. I think with Charlie Adelson, he took a horrible strategy, and I don't like to say horrible because it's such a strong term, but he took on a burden it became his job to prove this whole extortion theory, right? That became a burden that he had to prove, right? Which is the defense lawyer 101. You don't take on a burden, right? When I teach trial practice, not to Harvard students, but when I teach trial practice at Florida State Law, it's don't take on a burden. Don't do it, right? It's like the defense lawyer mistake 101. And that's what he did. And so I pray that he doesn't do that in this trial. I end every show the same every time, and I'll continue to do so. We say Wendy's Adelson's name so much. We say Donna's name so much. We say Charlie's name so much. This is all about Dan Markel, right? Like, we get lost in the true crime, and I love it, but we get lost in the prosecution of the criminals, and we forget about the man that was on the screen. And so every time I end the show with making sure that we give Professor Dan Markel his flowers, because he deserves it. A truly a good man. I tell people all the time that the people that I'm able to help in my practice, I'm now a lawyer in 3 states, Florida, Georgia, and Texas. And the people I'm able to reach and touch, a large part of it is because Dan Markel believed in me 10 years ago, and that he made a phone call and took a bet on Louis Baptiste when he had no objective reason to do so. But that single phone call that he made to get me an internship has changed the past 10 years of my life. And all the law professors at FSU Law, They all had, and I say it every time, so you guys have heard it, but it merits saying again. They all had degrees in law review articles. That was their door. That's what they had, not Professor Markel. Professor Markel's door was drawings that were made by his two boys. From the top of his door to the bottom, it was only drawings that only a parent could think were beautiful. But we're not talking about Picasso's. But that was what, from the moment you walked to his office, he wanted you to know before you knew about Harvard and Oxford. He wanted you to know that he was a father and that he loved his children. That's what that tells me. That was the most important thing in his life, more important than degrees in the big law firms. And so pray for his boys that they know that your dad loved you. And that's the legacy, that he was a loving father who cared about nothing more than he cared about his family. Thank you.
As always, very eloquent. Judge Jay Blitzman, equally eloquent. He is a retired judge, served as the first justice of the Massachusetts Middlesex County Juvenile Court Division. You heard he was also a criminal defense attorney, tried murder cases, and now he's a professor at a little-known school called Harvard Law, which I'm going to be attending in a year or so. By the way, I've been having a recurring dream that I am failing out of Georgetown Law School. I don't know why I'm sharing this publicly, but I've shared this with Carm the last couple of nights. I don't know why it's Georgetown Law, but anyway, I'm failing, and the dream makes no sense because in the dream I'm failing my physics class, which obviously you would not take at law school. But if anyone interprets dreams, please let me know. That's where Singer went. This is true. There's more.
Well, I can interpret it for you, Joe, but I don't think you're going to want me to interpret it in front of everybody.
There's more complexity. We'll get to it. You and I will discuss it, brother counsel. Always like to be transparent on the show. Judge Jay, are you good at spotting future Louis Baptistes and the great attorneys? When you're teaching at Harvard, do you and your colleagues say this is the one that's going to change the world in the legal profession? Martin Radner, of course, included. Your final thoughts.
In my final thoughts, but so first of all, this relates to your question. I really, my only regret is joining this conversation late because I've really learned a lot from my colleagues. I think it was Albert Einstein who famously observed, the more I learn, I know nothing. So we all think that we know a lot, but we've all got to remain humble, and listening and from my colleagues and hearing from them and listening to their insights is incredibly important. And as regards your question about spotting future Louis Baptistes, I'll just say this. So I teach
and Martin Radner's. Go ahead.
and brother counsel.
Louis.
I teach trial law at Harvard. I teach juvenile law at Northeastern. I teach a course called the Cradle to Prison Pipeline at Boston College Law School, and I always look for students whom I think have a passion for equity and are really interested in social justice. So I look for those attorneys. That's not to say that every attorney is going to go wants to become a progressive prosecutor or a public defender. Many go into what is now called big law. Of course, I spent my whole life, I guess, in little law. I'm drawn to the Louis Baptistes and the brother counsels of the world because that's where I find my energy and my sustenance, quite candidly. So, yes, there are attorneys or aspiring attorneys like that, and we know them right away. So I got a hunch, Luis, if you were in my class, I would have recognized you on day one. I would have said to one of my colleagues or to myself, this guy is the real deal. I'm going to go the extra yard to make sure I could be available for him and do everything I can to help him. And I got a real strong hunch. I was getting, quite candidly, rather emotional as you're talking about Professor Markel, because without knowing that professor, I know he was like that. And I know he saw something in you that really, really excited him and energized him. And I got a real strong hunch. That's why he did what he did. And your career and what you're doing is a validation of what he's all about. So thank you for sharing those incredibly evocative remarks about Professor Markel. Really very, very moving.
Nothing I can say other than we're going to be back tomorrow night doing Corey Richins, 8 p.m. Eastern time. These guests are the best of the best. Amazing. Their passion for the law, their charm, the charisma, they've got it all. So we will certainly have them back on. Appreciate you all being here. It was a doubleheader. If you missed the earlier show, you can go back and watch it on the replay. Until then, love you, America. Love you, Boston, Harvard, Watertown, Tallahassee, Detroit, Tallahassee again. And of course, it's all about justice for Dan Markel. We'll see you tomorrow night. Have a great one.
Peace out.